I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we're jumping into compilation number 174. Today we will be in 3 different judges' courtrooms. Before I give you the rundown on those judges, as always, don't forget to like, comment, share, and subscribe. Commentary will be left from these proceedings previously being aired here on the channel. Also, chapters will be added for your convenience. Now, let us get into the rundown of our judges. The first judge courtroom we will be in is that of Judge Brantley Clark out of the state of Florida. Second, we will be in the courtroom of Judge Richard Hillman out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Mark Slavens, also out of the state of Michigan. I hope you guys enjoy number 174. I thank you guys for all of the support and the feedback on the compilations. And listen, nothing else to do but jump into 174.
Mr. Salim represents either one of those.
Salim.
Your Honor, can I speak for the record too?
Williams. Finished knowledge.
Yes, sir.
So I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that. But considering the fact,
Your Honor, this man ain't even helped me in my
Marty,
defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
what I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365, the attempted murder case is a life sentence, in that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right, he's choosing not to do that. But I did want that on the record so that there was no confusion later on about whether or not I had informed him of the offers and how I advised him and that sort of thing. So,
Your Honor, my intention is to revoke those offers today, and I plan on moving forward next week. One thing that Mr. Williams mentioned, yesterday I filed the HBFO notice, which actually extends his exposure in the tampering case from 30 years to possible life in that case as well. Okay. So the maximum that Mr. Camardi faces is 2 life sentences consecutive.
Okay. I really wasn't aware of that. You hear what he said?
Yes, sir. But
so let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being that he's representing me, we haven't even worked the defense in this case at all, period.
Okay.
And plus,
let's take one thing. Do you understand that you've been offered 25 years in prison?
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
I don't understand because I'm innocent. I don't know what's going on. I don't know what.
Listen, you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum.
Minimum
mandatory.
mandatory minus the time you served in jail. No, I just need you understand that's the plea offer from the state.
Hell no. I don't understand none of this, what he thought. And it's a conspiracy between these two right here.
Listen, Mr.
Man.
Cromartie, Mr. Cromartie, what do you?
Man, I don't understand, sir. And
I don't believe you, Mr. Cromartie, because you act like you do understand it. What are you asking for right now? What are you asking for?
I'm asking for him to be removed off my
Raise
case.
your right hand to be sworn.
I do.
Wait till the oath is done, sir. Do it again, madam.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Jamel Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamel Cromartie, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my Fourth and Fifth Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my Fifth Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr.
Just don't
Cromartie,
understand.
what are you asking me today? I'm gonna give you
No,
one
I
more
don't
chance.
need him on my case.
Okay, are you listen, what are you asking me to
Or
do?
this one right here. This both them two right there.
Okay.
I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do?
Continue my trial.
No,
Till I
sir,
get-
motion denied. What are you asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right now, you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself or are you gonna hire another attorney?
I'd rather represent myself to get an attorney.
You already sworn in, so state your name again.
Jamel Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week, is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay? Do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court, is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you're agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that, is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest and that would settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
It's a
correct?
lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court. Is that correct?
I'm not gonna say I'm being truthful.
When you
I
said
don't understand.
you don't understand.
You got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't
understand.
understand because it's
So you don't
going on.
you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade,
And you read and write?
barely. I could barely spell.
Okay. And you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did.
do what I can that I've been trying to do.
Do you understand you'd have to do
I do
everything?
better than him.
Listen to me. If you want to represent yourself, you've got to answer these questions. If not, I can't allow you to represent yourself. So,
I ain't trying to make a fool of myself, but Yana, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're going to pick a jury Monday morning. I'm not continuing the case. And you're going to try the case next week if you represent yourself.
Okay.
And you read and write.
I'm gonna learn.
You don't have time to learn. So you can barely read and write. Is that correct? You don't understand about the plea offer. You understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm going to find that you're not competent to represent yourself. Mr. Salim will stay on his case. Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury.
All right.
Well, guys, we've come to the end of this proceeding. Not a whole lot to comment on, but I will say Mr. Camardi, first and foremost, definitely has his sovereign citizen head on and may not have his thinking cap on. And the reason why I say that is because of the 2 life sentences he's facing. You know, I can't say that somebody should definitely take the 25 years that he was offered, but I think it's definitely something to think about. And it's definitely not a good idea to, you know, pretend that you don't understand at least what the offer is. But nonetheless, this is a serious case. We see Judge Clark, you know, he got fed up with the back and forth. It's like, listen, if you feel like you're not guilty, we're going to go ahead to trial. If you don't feel like you want to take the plea, that's your prerogative. If you think you can prove your innocence, that's fine. But you see, he don't want his lawyer. He feels like his lawyer and the prosecutor, is conspiring against him. So I don't know. This is a tough one. It's a very serious case. You know, this young man's life is at stake, and hopefully he makes the right choice. And I'm not saying that that's definitely by taking the 25 years, because I don't know the facts of his case or what he did or didn't do, but it's definitely something to think about. But what I think he shouldn't be doing is acting like he don't really understand what's going on. He talks about, you know, he doesn't know how to read or write or barely or whatever have you. But some of the sovereign citizen stuff that he spewed goes to show he had to read that somewhere. And he's articulating himself pretty well when he wants to anyway. So with that being said, if we get any follow-ups on Mr. Camardi, we definitely will share it here on the channel. Thank you guys as always. I don't know why I'm so tongue-tied today, for joining me. I appreciate you guys. This is Sovereign Citizens Hall of Fame. Don't forget to like, subscribe, and share. It is much appreciated. With that being said, this is Sovereign Citizens Court. And for now, Sovereign Citizens Court is adjourned. God bless you guys, and thank you.
And sir, you are Amate Bay, is that correct, sir?
Yeah, I'm a Amate Bay, real party and interest in this matter.
Okay, are you driving a vehicle right now while you're on the hearing?
You said I'm driving a vehicle. Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15
you're.
seconds. I can pull it back up to my family house, and I'll stop.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor. For a second, I'll call y'all when I get back.
Okay, this matter is scheduled for a hearing.
Do you recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
And
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly.
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I disagree as tremendous. So,
Okay.
Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right, you may continue, Mr. Dewhurst.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
Objection, Your Honor. Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir, that's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again,
All
Your
right,
Honor.
let's take one issue at a time, gentlemen. I can't be
Yes, sir.
expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is.
On what grounds, Your Honor? Because I never got served
Sir,
directly.
if you stop speaking when I'm speaking, then I will state my grounds. And so
I
this
never
is the
requested
time.
that. You stated that, Your Honor. This is my first time requesting any adjournment to bring
Okay.
in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the truth on that issue. So
So, Your
objection.
Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
Was a government record and or document recorded with the applicable recorder of deeds for this this document?
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay. So the objection is that this witness doesn't have the
Firsthand knowledge to any other matters.
Okay. All right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overrule the objection.
Yeah, the property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that I got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own. He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not
Mr.
credible.
Bay?
That's not credible.
I'm sorry. This is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right. Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. So Brown and Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst. Is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Okay,
Again,
what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is
The
relevant.
relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm
So
not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for
Yes.
Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to you, to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor,
Yes.
I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay, I'm
Johnson,
sorry.
what's your objection?
Your Honor, he's asking the witness to respond to a vague request if he has any notice, but, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
No, Your Honor, I'm not aware of it.
That's an argument. That's not a question. This is a
Okay.
time for questions.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst, is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
Under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
Okay, also, for you, Your Honor, so it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
Understandable. So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Your Honor, asked and answered.
No, that's not asking to answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything.
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor. Not
Okay,
at this moment. I'll let my counsel deal with that.
okay. Does the plaintiff rest?
Yes, Your Honor, but if I may just conclude with a couple things, if that's okay.
Well,
Objection, Your
if
Honor.
you have
Statement
a-
and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that. This
Okay, I'm
is-
sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction on July 5th, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay, all right. That's all for the record. Thank you, gentlemen.
Thank you.
Your Honor. Have a nice day.
You as well.
Well, guys, we've come to the end of another proceeding. And for sure, this Moorish brother had his sovereign citizen head on 100%. Judge Hillman, to me, handled the situation quite well. We see that it was a foreclosure case. And, you know, right away, Amate Bay went right into the whole, you're practicing law from the bench. And to me, he didn't really have many arguments. It was just more or less him just really cutting the judge off. And as we could see, Attorney Ken Johnson, he was sick of it, man. He was tired of the whole thing, but he just kept cutting him off. It wasn't even really a whole much to do commentary on this one. He just kept cutting the judge off. And as we can see, the judge, because of his non-arguments, the judge found that the Carrington company would have the right to evict he and whoever else is on the premises. But I did see where he kept talking about some type of heavy hitter lawyer that he was going to have get involved. I don't know where this lawyer was at, why it couldn't be postponed until the lawyer got back from wherever they were from. But he kept talking about this person that was going to, really handle this situation. I mean, maybe they'll do that on appeal, but I don't know, guys. It wasn't really much to say. This guy, I don't even feel like, even though he said a whole lot, and I know this is common with sovereign citizens for them to say a whole lot and not be saying nothing, but it's like with this guy, he absolutely was saying a whole lot and not saying nothing. And to me, it was just him just being irritating and just cutting the judge off and cutting Mr. Johnson off. So with that being said, we see, obviously from what we all expected from when he first kind of opened his mouth and started talking, that he probably would lose this case. And that's exactly what happened. So with that being said, guys, thank you once again for joining me for another Sovereign Citizen Hall of Fame video. This is Sovereign Citizens Court, guys. And for now, Sovereign Citizens Court is adjourned. Talk to you guys soon. God bless.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tanaya Tubbs.
Ms. Tubbs, can you unmute and state your name for the record, please? And is Ms. Patillo standby counsel? Is that what this is?
Yes, Your Honor.
Okay. Ms. Tubbs, if you can state your name for the record, please.
Grand Rising. I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tanaya Nicole Tubbs, the beneficiary.
Okay. And Ms. Patillo is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that. But if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you, okay? You're gonna represent yourself, but if you have any questions, you can ask her, all right?
I hear you, sir.
All right. Do we have a jury trial date on this?
March 7th.
All right. We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, I would, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial.
And I have ruled that she can represent herself, haven't I?
Yes.
Okay, all right.
And that's why the other counsel was relieved and
Right, okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and your and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public would not hear.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patillo?
No, sir.
All right, Ms. Patel, I don't think I can order her to do that, so. Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. What would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me. Not being smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Ms. Tubbs. So she apparently, will you be willing to have Ms. Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you. I'm not willing to.
All right.
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
you're
you tell
forcing me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to him. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell me.
She can have her in the courtroom, but not on my behalf. It can be on her behalf since she's fearing what I have to say alone. I'm not understanding why.
Put the three of you in a breakout room to discuss things.
Okay, thank you.
Do you agree to that, Ms. Tubb?
I agree to speak with her with the third party on her side.
All right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay, thank you.
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
Is there anything else we need to take care of before we send you into the room with Ms. Tubbs? Is there any other matters that are ready? Madam Clerk?
Yes, we could take care of Mr. Keyhole.
Well, you know what? You know what? It's too complicated. Let's let them do this. Can you come into the breakout into?
Yeah, I'm gonna go into the conference room and log into Zoom.
Okay, all right.
People of the state of Michigan. People of the state of Michigan is the people on the benches. It's us versus us. This is sad. Oh, I pray we wake up.
Let's go back on the record with regard to Ms. Tubbs' case. All right, let's call Ms. Tubbs' case, please.
Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
And good morning, Judge Deanne Patillo, P82378, stand-in counsel for Ms. Tanea Tubbs.
All right, Ms. Tubbs, if you can unmute and state your name for the record, please. All right, you can speak now. I think it's unmuted, ma'am. Yep, I can hear you. Yep.
For the record, I am Tanea Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. Do you agree to waive that right for today and hold this hearing by Zoom?
Correct.
Okay. All right, where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs, and I did look up I know that the defendant is in Calhoun County Jail right now, and that she has a sentencing date of March 24th, 2025. When is our trial date? The 17th?
March 17th.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here, and maybe we should have a pretrial before the trial once Miss Tubbs is here, where we're all in person. And Miss Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th, if that works for the court prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay. All right.
Excuse me, Your Honor.
Yes, go right ahead, man, Ms. Tubbs.
I am looking forward to being out of here before then. And it is my duty to come there on my own as a freeborn sovereign to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district, and I'm not going to be able to get this paperwork if I don't be able to walk and go get it, go home and print it out myself, because I have none but 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to help me any longer.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're gonna be in the jail here, Wayne County Jail.
What I'm telling you is that I'm gonna be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity or am I entity. I am a living being.
All right, you have a nice day, ma'am.
Well, guys, we've come to the end of this second appearance for Miss Tanea Tubbs. And I must say, I feel, a little bad for a couple of different reasons. But I'll say this, one thing, that sometimes is kind of unfortunate and it's hard to understand, but I guess it shouldn't be hard to understand, because obviously with the sovereign citizens, they're in their own world, they're believing, their own lies, own script, whatever have you. But, sometimes to see them not understand how beneficial standby counsel can be for them, because you're still representing yourself. But if you run into a snag, you can ask this individual, like, listen, what should I do here? Or what can I do here? And a lot of times, you'll see them, they don't allow themselves to benefit from that. And I think it's because they feel like these attorneys are also a part of whatever conspiracy is against them, or whatever it is that the court is trying to do to them. Like, even when you look at Miss Tubbs, when you think about it, when they were trying to do the breakout room with her, the prosecutor, and the standby counsel, in her mind, she was processing it as the prosecutor wanted to hide something that she had to say that she didn't want the public to hear because it was basically, it would be exposing the prosecutors, because she kept saying, oh, she's scared, you know, because she's scared of what I have to say. She wanted to go into this private room, not processing and understanding like, no, we're going into this private room to protect, you know, your business and protect, you know, what it is that we're going to talk about when it comes to your case. And the standby counsel being there, it's just kind of like a referee to make sure the prosecutor don't say anything crazy and she doesn't say anything crazy. But for her to take that as like almost like a conspiracy type situation, it just goes to show where a lot of, you know, these different sovereign citizens' minds are. And also, you know, it was just kind of hard for me to hear that she has 8 children. Obviously, we all got to be held accountable for our actions. So, you know, that's what she's going through right now. And unfortunately, her oldest son, she says, is in jail. And, you know, probably because she's going through her situations, you know, and you know, I don't know what their household is like or where they live. But obviously, if she's dealing with jail and not really there with him, and the environment is about that type of lifestyle or those type of lifestyles, then more than likely that's why he's following down that path. So I'm hoping that, you know, once this goes to trial and everything, that it gets squared away, she gets out and gets her life together. But we'll see. We're going to definitely keep following this case for you guys and keep you updated on it. And with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless you. Thank you for joining me. See you on the next proceeding.
I'm not threatening you. Say one more word and that's 30 days. 30 days.